that you're answering the questions in the invention disclosure of how it's relevant to the collaboration. If we take a look, as I mentioned, a little bit more detail on the extraction side, one of the things we have found, of course, is that there's a lot of intellectual capital in an organization, and it sort of bubbles up. These ideas bubble up. If you can provide a formal extraction session on top of the bubble up, you can extract it, and that can then be put sort of in your intellectual property bank to add to the value. And so if you can identify these key inventions through an invention extraction session, you can do a lot of work to then codify these titles and abstracts in terms of a database. And you can see here is a particular plot of a database of invention records by a couple of parameters, like where they are in development phase and where they are by time horizon. And you can see that we have a number of inventions that are in production that are in the past and today, but you can also see that we have a lot of concept inventions and a lot of inventions that maybe might have some early feasibility out in the future. So by mapping your inventions to a map like this, you can determine what is going to be added to the collaboration that you know has value sort of in production, but you can put some value on inventions that are in concept or maybe need more development. But no matter what, at least you own those. At least you own those. Another thing that we can do is to establish an agreement to use third party by separately scanning for each invention relative to partnership from both sides. In other words, you could require that not only that you extracted inventions for your intellectual property prior to the collaboration, but as part of the deal you could require the other side to do it. And if you have an all-in where you can match up all your inventions against all their inventions, you now have a sound basis for comparison. So you can see that your inventions here versus your partner's inventions, before the collaboration, you may find that you don't have as much, but you may find that during and after you can build a larger portfolio of inventions. So it's really important to use these scan results to establish ownership before the transaction. But also you want to do these extractions during and after as well. So during the partnership, as we shifted from before the partnership to during the partnership, one would ask that formal invention extraction sessions be done of both your side and their side and of the collaboration related to the field of use. So you can start to really build good context up of who owns what. If you think about what I'm talking about, how many companies would go to the level of having formal quarterly invention extraction sessions of the partnership? Usually after the partnership agreement is made, people start working and they forget about this whole idea of extracting inventions. And if you don't formally extract it, what's going to happen is you're going to leave it up to the inventors, who chances are they don't know what invention really is. They probably won't document as much as you want them to. And the second thing that we can do during the partnership is to be very important to establish what IP you are not contributing. Here what we want to do is build into the contractual agreement what happens if either party violates IP that's excluded from the sharing arrangement. What you want to do is really clarify in this model here, define and protect the IP that's not contributed to the partnership at all stages. So you can see there could be a very large amount of intellectual property developed that could even be outside the partnership as a result of the partnership, and you want to include in your contracts what to do